Bruce Rivers, he's the criminal lawyer.
But who is he?
Bruce Rivers, he's the criminal lawyer.
And who is he?
Bruce Rivers, he's the criminal lawyer.
And what he do?
And he's gonna react to all the self-snitching.
Hi, this is Bruce Rivers. Welcome to another fun-filled episode of Criminal Lawyer Reacts. I'm Bruce Rivers, board-certified criminal defense lawyer. I'm board-certified by the National Board of Trial Advocacy and the Minnesota State Bar Association, which means I am a real lawyer. I have real experience, 25 years as a matter of fact, and I still try cases. I've tried 11 cases in the last 12 months. Today we're reacting to Alex Murdaugh and his murder case. This is a very high-profile murder case, but before we react to that, guess what? This is brought to you by eSign.com. eSign.com. eSign.com is an effective way to remotely sign documents so you can execute business, flash. So let's say, for example, you're Alex Murdaugh and you're sitting behind custody and you need to execute a document. They give you an iPad. Sometimes they do that in jail. And your lawyer says, look, I need another $100,000. Well, you need to sign on the dotted line. Otherwise, we're not going to continue to be your lawyer. Well, you can do that through eSign.com. You download the app, you get 3 free signatures a month, and it's amazing. I actually use it in my practice, and you guys can use it for anything, for power of attorney, for any kind of document you need. You got people across country, you need to sign something quickly, you can have them do it through eSign.com. Follow the link below, download the app, you're covered. So let's talk about Alex Murdaugh and what he's facing with murder of his son and his wife. So let's start out with what kind of a hole you're in the minute you're charged with killing 2 people. Charged. I didn't say he's guilty. I said he's charged with killing 2 people. He's charged with killing his wife and his son. Heinous crimes, right? I mean, because if you believe he did it, I mean, who could really do something like that? You have to be a monster to do like that. And you kind of not want to believe it. But guess what? When you do jury selection in a case like this, it's very tricky because you've got to find people from the defense perspective who who don't believe right away. In other words, they presume your client innocent, and they're going to do that throughout the trial. Tough duty. Because when you are, like, let's say you talk about the nature of the crime itself is the hole that you're in. So the defense has got to dig their way out of the hole. So let's kind of go over some of the evidence that's in this case. So according to some court testimony just recently, there was a text that was sent at 9:47 p.m. on June 7th, 2021, after Maggie, his wife, was already dead. And then there were a few phone calls after that. And the prosecutors say that he was doing this because Alex Murdaugh sent this to his wife in an effort to create an alibi. So wherever you go, no matter what you do, you leave a digital footprint. You just do. Because you have one of these things, you have one of these phones. Guess what? Your location is on or your cell signal is on. You make a phone call, it goes to a cell tower, it records your geographic location. So your GPS coordinates. And so if Alex Murdaugh is texting or calling his wife, it's going to record where he is at that time, right? But it'll also record him going this way or going that way or going whatever way. So they have some text messages and a phone call to her saying, call me babe, whatever. And they heard testimony from an expert, Britt Dove, who works in the computer crimes lab for South Carolina law enforcement. And she talked about her phone usage. And she meaning Maggie, had made a phone call that lasted about 3 minutes. And then shortly thereafter, they're saying that it captured an image of, the phone turns off and then like somebody picked the phone up abruptly and, and it activated the camera. And all this data is captured on the phone, right? And the prosecutor is saying that this is evidence that the phone moved quickly and that somebody had picked up the phone. So according to Ms. Dove, who is the state's expert on the phones, Maggie had made a phone call at 7:50 p.m. Now, let's see, and Alex's phone calls were like at 9:47, like 2 hours later. After that 7:50 phone call, 7:50 p.m. phone call, prosecutors say she never used her phone again. But at 9:07, after she's presumably dead, that's when the phone camera is activated. So if it's picked up, if you pick up the phone and you look at it, like if you just go like this, it activates, right? And so that's recorded on the phone. And here's the other thing. Her phone was found outside the gates of the estate, like discarded somewhere. And according to Dove, her testimony was, it appears the phone was being moved and the camera's activating in the background to see if it would recognize somebody's face and that would unlock it. Now, they're saying seconds later the orientation of the phone changed. In other words, it moved this way or that way. And she can tell this by however. And that's indicative of somebody moving the phone. Now, when you have this kind of evidence, you can use it for the defense, or you can use, I mean, it doesn't say that he necessarily touched the phone. It could have been an intruder that did that. So wherever Alex Murdaugh was, his whereabouts are going to be known, because the prosecutor is saying that he was visiting his mother and that was his supposed alibi. But if he was really visiting his mother, that is an alibi, right? Shortly after 10 p.m., he calls 911. Now, is it intuitive that you would call 911 if you didn't do this? Of course it is, because your wife is dead, your son is dead, and they're gunned down in a heinous manner, of course. Or would you be smart enough, because you're a lawyer and you got so much shit going on, that you decide to create an alibi for yourself? So you call 911 because you're going to be the first one they look at. According to Maggie's phone, there were 3 missed separate calls in the next 40 minutes at approximately 9:47 p.m. and a final text that said, "Call me, babe." And then shortly after 10 o'clock, he supposedly stumbles upon the bodies and calls 911. Now, the defense is saying that he was a loyal family man, and he was a father and a good husband and all this stuff, right? But there's so many other questions, and I don't know how much of this stuff is going to come into play in terms of what's coming into evidence in this case. So when you have a case and you have a lot of bad facts, like the prosecutor wants to get other bad acts that really have nothing to do with the case itself, but may provide a motive or context for somebody, what they do is you file motions ahead of time, and then you argue that stuff ahead of time. So there's a couple things. He had a housekeeper that passed away under suspicious circumstances, and he somehow made off with $4.5 million of her money that she got from a settlement that he probably effectuated for her, right? So, and then there's also the fact that he embezzled from his own law firm and other crimes, that he's looking at a lot of other shit. And the prosecutor is going to try to create this picture that this is the guy who did all this stuff. And he did it. Why? He did it because he's sort of fucked. He's fucked here, he's fucked there, and he's got to get himself out of this jam. And so if he kills I don't get how he kills his wife and child, how somehow that, maybe there's insurance. I don't know what the motive is to kill his wife and son. According to court testimony, this guy, who was a very prominent attorney in South Carolina, shot and killed the pair that evening, and they say that he changed his clothes and visited his mother to establish an alibi. So they say that the phone and text records are just an attempt to create an alibi. So Paul was shot in the chest at close range. Maggie was shot multiple times and in the back with .300 blackout, which is like a .223 round, only it's a little bit bigger. And so that's like what you have in it's kind of a specialized round. You wouldn't expect just some random intruder to have, a firearm like that, right? I mean, it's kind of from an assault rifle. And so when you put all this stuff together, defense has just a tough hill to climb. It's a circumstantial case. and we've talked on this channel about circumstantial versus direct evidence. There's no like ring camera that catches him in the act, right? There's no indoor camera that catches him doing X, Y, or Z. And we all know there's plenty of cameras all over the place. And her phone is found outside the gates of the estate. Now, if you look at where his phone is that entire time, that could be exculpable evidence worthy of an alibi. You know, I was at my mother's. But you could go see your mother, right? In a nursing home or assisted living facility. Leave your phone there. Go do them dirty. And then go back and you're not tracked. Correct? Right? You could do that. That would be smart. I always said, and I won't ever commit a crime this way, so this is not self-snitching, but I always said if I was going to commit a crime, I'd take my phone and I'd either try to hide it and get on the light rail or get on the bus and find some poor sod and put it in his backpack and then fucking take off. And then whoever is looking for me is going to look for that backpack, right? So if you're smart like that, and he's a established lawyer, he knows how all this shit works. So his digital footprint is going to be minimized because he's a savvy consumer of the judicial system. So when initially confronted by police, Mr. Murdaugh put a defense up that he knew what it was about, saying his son was involved in a boat accident, saying he's been getting death threats. Most of them were benign, but we didn't really take it seriously. And here, let me tell you something, what people do when they get busted. Nobody thinks really great on their feet, to be honest with you. I mean, you try to come up with some bullshit story, and it's usually going to fall flat. Because if he's been getting death threats, has there been a police report? If there hasn't been a police report, is there any digital evidence of it? If there isn't any digital evidence, how do we know what the fuck you're saying is true? So he's trying to throw them off track. Here's the other thing. When you make all these statements, so for example, he made a statement that he was being kicked out of his law firm, that he'd been shot in the head, that he wanted to die because he wanted to leave his older son Buster a $10 million insurance policy. I mean, all that stuff's coming into evidence. Anything somebody says, anything a defendant says, because it's a statement of party opponent, you've heard me say that term many times. Statement of a party opponent. That means the person that's going against the plaintiff is the state, the party opponent would be the defendant. So anything out of Alex Murdaugh's mouth that's remotely relevant to what we're talking about here, and anything related to a motive, is certainly going to come in. All that's, so you're really starting out in a hole. And the defense is saying this is all circumstantial. There's no hard evidence to suggest he did anything. And so as we follow this, even if he is acquitted of these homicide charges, he's facing all kinds of other theft and fraud charges and money laundering, probably some other major charges related to some financial mismanagement or some misappropriation of funds related to his law firm. And why is that important? It's important because he can't take the fucking stand. He cannot take the stand because guess what? Some of this stuff only comes in if he testifies because it bears on his credibility, right? And so if he testifies, he can't get up there and say, I didn't do this. And the reason he can't is because he's going to get eaten alive by any prosecutor because they're going to shove all this crap up his ass. Now, guys with this much hubris, though, and by that I mean full of ego, no concept of consequences, and it is go for broke. So he may wind up testifying anyway against his lawyer's advice because the lawyers will probably say, you get up and tell this bullshit story, you are going to get eaten alive. Maybe true, maybe not true. I don't know. I'm just viewing it from my own lens, going through these processes before. So we're going to follow this case, And there's a lot to this. There's a lot of moving parts. Tragic scenario for this family. Just absolute tragic. And I still don't have a great motive for him to kill his wife and son. Tell us about it in the comments. So we'll see you next time here on Criminal Lawyer Reacts. I'm Bruce Rivers. Thank you for supporting our channel. Make sure you sign up for Patreon. Follow us on Instagram. Follow us on Twitter. Stay for Percy Mac. We'll see you next time here on Criminal Lawyer Reacts.
Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. 23-hour lockdown, please just at my God.
Bruce Rivers, he's the criminal lawyer. Bruce Rivers, he's the criminal lawyer. Bruce Rivers, he's the criminal lawyer. And what he do? And he's gonna react to all the self-snitching.
Hi, this is Bruce Rivers. Welcome to another fun-filled episode of Criminal Lawyer Reacts. I'm Bruce Rivers, board-certified criminal defense lawyer. This episode is brought to you by eSign.com. eSign.com. If you have a document that you need signed, no matter what it is, go to eSign.com. It's a very easy way to get people to sign a document when you're not there in person. I use it all the time in retainer agreements, in plea agreements. It makes remote deals really easy. So go to eSign.com and make sure that you use their product. Today, we're reacting to Boston Richey. Boston Richey is a rapper. His name is Jalen Foster. What I'm going to talk to you a little bit about is snitches, okay? Snitches are throughout our judicial system. The federal government uses snitches on just about every single case, especially the drug cases. But there's a real danger when you label somebody a snitch and they're not a snitch. That's why they're not labeled in documents as their name. Usually witness A or B or whatever. 1090 Jake has posted a video alleging that Boston Richey is a snitch. And it is so reckless, and I'm going to read you the only evidence he has of that.
Florida rapper Boston Richey and his paperwork being exposed.
That sounds so ominous. His Boston Richey and his paperwork being exposed. Like he's a snitch and he's the one that's responsible for the conviction of DeAndre Wiggins. Let's just back up a little bit. DeAndre Wiggins in 2016 was responsible for the murder of Tavares Bass. Tavares Bass is Boston Richey's cousin. That's a well-known fact. There is a gun. They had DNA on the gun. They had Mr. Wiggins' own statements that he inculpated him, and he pled guilty. So there wasn't a trial. There was no snitch that testified against him. And so let's kind of look and see what exactly Mr. Foster or Boston Richey, what he said actually. He was interviewed and he lived at the same address. So witness 3, and let's say witness 3 is in fact Boston Richey, was interviewed. Witness 3 is a relative of the homicide victim and resided at Keith Street residence where the homicide occurred. Nothing wrong there. Witness 3 reluctantly recounted an incident that occurred approximately 2 months prior involving the defendant. So he's not even talking about the murder that happened. Witness 3 stated that he or she had been in a Frenchtown neighborhood when the defendant threatened him with a firearm. The incident supposedly occurred because Witness 3 was associated with Tallahassee's South Side. That's not snitching. In fact, if you're being accused of something, that's you standing up for yourself. That portion of the probable cause statement is really foundational and really can't be used to inculpate Mr. Wiggins on this case. Mr. Wiggins was scheduled to go to trial, and he didn't go to trial, but 2 of the witnesses have recanted their statement. There is no evidence that Mr. Richey or Mr. Foster was going to testify in this case. When you look at 1090 Jake's presentation of evidence, he puts up a document that says witness list. But just because somebody appears on a fucking witness list doesn't mean that they're going to be a witness. Here's what I do in all my cases. I take every single person that's named within a police report, no matter where it is or what they think they have to offer. I put everybody on our witness list. That way, everybody's included in case maybe they have some nugget that you're going to use later and you didn't think about. And if you don't have him on your witness list, you can't call him, right? Saying he's a snitch and giving this sensational bullshit about paperwork can get people killed. Well, 1090 Jake should not have gone where he went with this. I think it's really dangerous. There was an original post by one of Kodak Black's NFL 2-Wop, and he posted some shit about Boston Richie, about his paperwork. Take a look at the paperwork. That's supposedly where this witness list came from. And when you have ops or whatever, people talking about this and talking shit like that, this kind of talk can get somebody killed. I've got the probable cause statement right here, and I've gone through it in detail, and there's absolutely nothing in here where he says, I saw him kill them. You know, I mean, it just didn't happen. So here's the only other portion of the affidavit or the probable cause statement where Mr. Ritchie is named, or at least witness 3 is named. The defendant admitted to knowing witness 3, the relative of the victim. The defendant confirmed that he and witness 3 had a past altercation, which is the same thing we heard earlier. The defendant, that means Mr. Wiggins, denied witness 3's account of the altercation. He stated that approximately 2 months prior, witness 3 and his or her brother had arrived on Dunn Street armed with Kalashnikov, AK, style assault rifles, and threatened him. So the cops know about this stuff. If Mr. Ritchie is recounting something that happened before, it has nothing to do with this. But it had everything to do with a beef that he had, and the two of them gave varying accounts. At the beginning of this, it's sensationalized. And it's sensationalized in a way to say, hey, look, oh my God, he's a snitch. That's really what it's trying to say. But let's just listen to exactly what he's saying.
Investigators interviewed witness 3, who according to the witness list is Jalen Foster.
Now let's just say, according to the witness list, whose witness list is it? Court doesn't give you a witness list. The witness lists are presented by parties. So did Wiggins put him up as a witness? Or did the state put him up as a witness? He doesn't tell us. And here's the thing, when you look at that video, there's no pleading heading. You know, if you look at what a pleading is, it's got a caption to it. This is what a pleading looks like. Do you see how it has a caption? Do you see that font? Do you see how it's written out? Look at his witness list in that video, and we'll show you that to you in a second. It is not in the format that they use. It's a made-up document, because whoever is the proponent of the witness list has to identify themselves as filing the defense witness list or the state's witness list.
Ritchie reluctantly recounted an incident that occurred approximately 2 months prior involving Wig.
So all he's doing is reading exactly what I read to you. He's reading the probable cause portion of the statement. And there's nothing in there that he says about this incident at all.
He stated he'd been in the Frenchtown neighborhood when the defendant threatened him with a firearm because he was associated with the South Side.
He threatened me? No, he threatened me. They're both saying the same thing, and both of them gave statements.
Roughly a week later, investigators interviewed witness 4, who according to the witness list is Trey Moore.
And you see this witness list that he shows here? That isn't how you black things out if it's a true witness list. Somebody just took a marker, and that wouldn't be filed with the court. And that's the other thing I checked on this thing. I looked at the court filings. Nowhere is that witness list filed. And it doesn't even fucking matter. The guy entered a plea. Nobody testified against him. And 2 witnesses, could have even been Mr. Ritchie, recanted their account of what their statement was to the cops earlier. This is really reckless stuff if you're not 100% sure. And even if you are sure, calling out somebody as a snitch can be very, very, very dangerous. So the long and short of it is this. 2 of the witnesses recanted. What does recant mean? Recant means that you go back on your statement. So you say one thing, he did this, and then you get up to trial and say, nah, he really didn't do that. I was wrong back. So you recant means you go back on what you said. So what I said before wasn't true. And so the state's case actually got weaker because those 2 witnesses recanted. So they probably offered him some other kind of deal that limited his prison time, and he took a deal. And he pled no contest. But it has absolutely nothing to do with what Mr. Ritchie said or didn't say.
He took to his Instagram posting Wig's statement and said, y'all gonna keep flagging or y'all gonna drop your nuts and speak on some real shit.
You got Boston Ritchie standing up for himself. Like I said, there's nothing in the probable cause statement which is, Jake goes through this whole probable cause statement. He reads it word for word. And I'm not going to do that here and bore you with that.
Everybody know fool ratted on me. I don't be speaking on shit or chasing clout like you jits. I been outside, never been police. Fool, the reason I even became a witness in the case, he told Troll we pushed up with the Blicks. What's crazy is the contradiction in Boston Ritchie's post. He's claiming Wig snitched on him by telling the police he pulled up with guns.
And he did. Wiggins did say that.
And because of that statement, Boston Ritchie became a witness. But this is a lie. According to the affidavit, Boston Ritchie was interviewed by police on June 23rd, the same day he was arrested for loitering and prowling. Wig wouldn't be interviewed until June 29th, 6 days later.
It doesn't matter. The dates don't really matter. What matters here is that even in the probable cause statement, Wiggins does say that Richie pulled up on them with guns, and Richie just flipped it around and said he pulled up on us with guns. So it's a distinction without a difference. I think if you look at what Jake is saying, doesn't hold water. And you could legitimately be talking to the cops, and you don't know what the questions are. You don't have the recordings. So you could legitimately try to stand up for yourself because this is what I know. You know, because you're pointing the finger at me about going after him with guns. No, this is what really happened. And by standing up for yourself doesn't mean that you're a snitch. Really dangerous to kind of go down this road. You know, if somebody's a snitch, to be honest with you, I wouldn't say anything about it. Me personally, I don't like snitches. I don't represent snitches, but snitches are part of our culture. They're part of the DNA of the U.S. Attorney's Office. That's just what they do. That's how they build all their cases. They have a network of snitches, especially on drug cases. They get somebody who's a runner or somebody who's an addict. Okay, who's your source? Who's your source? I'll let you off for free. But to expose a snitch puts their life in danger. He was interviewed by the cops. So the fuck what? He didn't testify. He never testified at any hearing, and it doesn't even say he was even there.
Instead, he identified Wig by a photograph to police, told them he'd previously been threatened by Wig, and maintained that the Key Street murder was not a result of the altercation or any criminal gang activity Richie may have been involved in, meaning Richie wanted to clarify to police he had nothing to do with the murder. But his sworn statement would make him an official witness in the murder case.
His sworn statement, first of all, his statement wasn't sworn. Second of all, he's got no power. The police run up on you, they arrest you, do whatever. You can give a statement or don't give a statement. Generally, what do I say? Don't self-snitch. And he didn't self-snitch here. And because he shows up on a witness list doesn't mean that he was necessarily going to testify. I just don't like to see people get exposed to potential danger where it's not warranted. And here, it isn't warranted.
And his name would be concealed because the information he provided.
And look at this document. Remember what I told you? There's no caption on here, so we don't know who authored this document, right? And it is just, and witness lists do not look like this. They just don't. And this list is not on the docket. You would have to file your witness list. And then if you're going to black somebody's name out, you don't think that the government, if that's their witness list, has a function on their word processing program, on their Word, where you black something out a little more neatly than with a fucking magic marker? That's what that is. This is just somebody doing whatever they were doing. When you're confronted with an allegation, it is not snitching to defend yourself. It just isn't. So I think this unfairly characterizes Boston Richie as a snitch. And
Wig would later plead no contest and be sentenced to 15 years in prison for second-degree murder and possession of a firearm by a felon.
He actually got a pretty good deal. 180 months is not that bad on a second-degree murder case. 180, you probably do 100. No, 180, you do probably 120, generally speaking, depending upon what state you're in. So it does sort of sound like a beef between Tuwop and Boston Richie. So one of the ways that you can test the validity of a message, what's their motive? And you look at the documents that Jake was given, it was posted by Tuwop. It doesn't pass the smell test. He wound up pleading guilty. Nobody fucking testified against him. When they talk about sworn testimony, the witnesses in there didn't swear. They're not under oath. It's the person who created the affidavit. It's the cop who created the affidavit that's under oath. Not anybody else. So none of the witnesses 1, 2, 3, 4, none of them are under oath, but they're in the affidavit. They're not under oath. It's the cop who signs that I talked to these people, this is what they said. He's the one that's under oath. So this has just been our little take on Boston Richie, Jake doing a little sensationalized video. I think it's really what it amounts to. I don't see the snitch central as Jake lays it out. So this is Bruce Rivers, Criminal Lawyer Reacts. Make sure you sign up for Patreon. Follow us on Instagram. Become a subscriber, for Christ's sake. And we'll see you next time here on Criminal Lawyer Reacts.
Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. 23-hour lockdown, police is at my god.
Bruce Rivers, he's the criminal lawyer. Bruce Rivers, he's the criminal lawyer. Bruce Rivers, he's the criminal lawyer.
And what he do?
And it's gonna react to all the self-snitching.
Hi, this is Bruce Rivers. Welcome to another episode of Criminal Lawyer Reacts, where I'm a board-certified criminal lawyer, and I am here to talk about the Petito situation. Gabby Petito. She was missing in the Grand Tetons. They think they might have found her body. And her Brian Landry, her fiance, has now gone missing. So let's kind of dive right into this. First of all, we're going to touch on domestic violence a little bit. Domestic violence is no joke. And let me tell you something, guys. It can happen to guys, but it's really not that common to happen to guys. So I'm going to talk to the guys. You never put your fucking hands on a woman. Ever. You never put your hands on a woman, ever. I don't care what's happening. You just don't do it. You've got the upper hand 9 times out of 10, and you just don't put your hands on a woman. Period. There is just no ever excuse for domestic violence. And here's the other thing. I do a lot of different kinds of cases. I have done murder cases with domestic violence. I've done regular domestic violence. And let me tell you something about people who are generally charged with some kind of low-level misdemeanor domestic violence. People that get pissed off or drunk and they feel like they have to put their hands on their woman. They are pains in the asses. These guys, they're usually pretty cheap. They don't like to pay. Number 2, nothing is ever their fault. And they generally know more than you do when it comes time to the case, because they've tried a lot more cases than you have not. Anyway, that's just my little spiel on domestic violence cases. I do like a good homicide. Don't get me wrong. There's nothing like a good homicide between friends is what I always say. But a domestic violence case that ends in a homicide has a different complexion to it than, say, a couple drug dealers where somebody needed a good killing. You know what I'm saying? Or where there's a kid involved. Those have a different complexion altogether. And sometimes, when you're having a case, sometimes it can turn your stomach. But you got to you have to do your work. And everybody's entitled to a defense. Everybody's entitled to the presumption of innocence. And it's the government's burden. The presumption of innocence means that the government has to prove their case. You don't have to prove your innocence. You're presumed innocent. And that is the way our criminal justice system works. So let's get into this case a little bit. So the Petitos, the Petito and Landry, Gabby and Brian went on a cross-country tour. And they got a new van, and they started out in June. They somehow wound up in Wyoming, which is just a beautiful area. They were at near Bridger Bowl in Wyoming, which I've skied that area. It's absolutely gorgeous. And so they wind up there in about August, and they come upon, they're doing whatever they're doing.
Bruce Rivers, he's the criminal lawyer. Bruce Rivers, he's the criminal lawyer. Bruce Rivers, he's the criminal lawyer.
And what he do?
And it's gonna react to all the self-snitching.
Hi, this is Bruce Rivers. Welcome to another fun-filled episode of Criminal Lawyer Reacts. I'm Bruce Rivers, board-certified criminal defense lawyer. First of all, I want to thank all of you for tuning in. This is today we're reacting to I'm going to kind of break down the pleadings that are in this case with Johnny Depp and Amber Heard. There's a complaint that was issued by Johnny Depp. He's suing Amber Heard, okay? And then she has to answer that complaint, and then she's counterclaimed. So she's got her own claims that she's making against Mr. Johnny Depp. Now, first of all, I'm a criminal defense lawyer, and the burden of proof in a criminal case is beyond a reasonable doubt. It's the highest standard in any of our cases in our judicial system. Okay. The standard in a civil case, which I do trial civil cases from time to time if they're, decent sized civil cases. In fact, I'm trying one this August. I have a client that's been burned over 40% of his body, and they had to use 40% of the rest of his body for a skin graft. So we do try civil cases, but the standard in a civil case is slightly more true than not. So 50.01%. And here's the other part in a civil case. There's a thing called comparative fault. You don't have that in criminal law. But a comparative fault is, I sue you, you answer, and you say, well, I may have done this, but you're at fault because X. So like in a car accident, for example. I may be at fault for the car accident, but you might be 20% at fault. And then what happens is whatever damages you get from an award gets reduced by your own fault. That's the other part of it. But here, let's dive into what the claim is by Johnny Depp. The first, claim, when you issue a complaint to somebody else, you're suing them, you have to state what your claim is, okay? And count one is for defamation for statements Ms. Heard's December 2018 op-ed in the online edition of the Washington Post. And here's basically the nuts and bolts of this. The sexual violence op-ed contained the following false and defamatory statements concerning Mr. Depp. Amber Heard, I spoke up against sexual violence and face our culture's wrath. That has to change. The implication, even though she doesn't mention Johnny Depp there, the implication is she was married to him at the time, and she's talking about things that she says she's personally experienced. Then, 2 years ago, I became a public figure representing domestic abuse, and I felt the full force of the culture's wrath for women who speak out. And then another statement that's in the complaint is that I had the rare vantage point of seeing in real time how institutions protect men accused of abuse. The implication there is that the institutions are protecting Johnny Depp. I write this as a woman who had to change my phone number weekly, which is probably bullshit, because I was getting death threats. From who? For months, I rarely left my apartment, and when I did, I was pursued by camera drones and photographers on foot, on motorcycles and in cars, tabloid outlets that posted pictures of me, spun them in a negative light. I felt as though I was on trial in the court of public opinion, and my life and livelihood depended upon a myriad of judgments far beyond my control. And so the claim is that these statements are concerning Mr. Depp, that's right out of the complaint, and he is Mr. Heard's former husband, and she publicly and falsely accused him of domestic abuse in May 16. So that's the first count, right? And then there's two other counts. Defamation for statements in Ms. Heard's December 2018 op-ed in the print edition in the Washington Post, and it's basically the same statements that we're talking about. And count 3, defamation for statements made in an op-ed in which Ms. Heard republished when she retweeted the link. So what do you need for defamation? Especially when you have a public figure like Johnny Depp. You need a false statement that is malicious. In other words, she has to know what she's saying is not true. So it puts Johnny Depp in a position where he has to prove basically that he didn't do this. There's almost a presumption that he did this, in the article. He's got to prove that it's false and that she knew it was false, and she did it with malicious intent. And if you look at some of the witnesses that he's presented, for example, his security guard did some damage to Amber Heard and the way she presented things. And I don't think that the cross-examination of him damaged any, but he was there at their honeymoon. He was there and saw them on a number of occasions. So the actual substance of whether there was domestic violence or not, there were certain fact witnesses. For example, the limo driver. He testified, and this was supposedly right after some abuse had occurred, that she looked like she was just having fun, and he drove her to Coachella. I mean, she wasn't being taken to a shelter or to the ER or anything else like that. He was taking her and some people over to Coachella, which is a famous music festival. So when you have those snippets of people who have actually seen her right around a time when some domestic abuse is supposed to have occurred, and it doesn't pan out for her,
that helps Johnny Depp a lot. But he can't just show that he also has to show that he was damaged by it. So you have to prove your damages. And in this case, he was able to, I think successfully, because one of their experts was a movie expert. And he was able to say that, the franchise didn't hire him for Pirates 6. And, and I thought it was inartful how the Miss Heard's lawyers tried to impugn their credibility on the success of Pirates 5. He says, well, the amount of money was going down, wasn't it? And all of a sudden, yeah, but it was $800 million, so, and anybody would love to have an $800 million movie. Of course they would. And then they have his accountant. And his accountant was able to talk about various spending patterns and various things with regard to his finances. Then you also have the ACLU person who testified about various donations that were supposed to be given. And that called into question Miss Heard's integrity and her truthfulness, because she said she donated, all 7 million, and it turned out not to be true. So now the plaintiff in this case has rested. So here's how it goes. The plaintiff goes first. They present their witnesses, and then, the defense cross-examines them. Then they rest. And after they rest, the defense has a chance to now present their case. Now, what is the defense going to do? This is Amber Heard. And here's the other thing. When the plaintiff is doing their presentation of their witnesses, they also sort of have to refute the counterclaim that Amber Heard is presenting. So you've got two things going on at the same time. So that's what makes it complicated. You've got Johnny Depp putting forth all his 3 claims of defamation, basically. And those are fairly simple and straightforward. But then with each witness, if they can knock out the counterclaims, they've got to try to do that as well. So that's why some of the questioning has been all over the map. And so the expert that Johnny Depp called, the psychologist, she was called to testify to refute the claims that Miss Heard was bringing. So that's why she was able to have, let's just talk about what those claims are. One, she wants a declaratory judgment per Virginia code under 801. And basically, Miss Heard requests that this court, pursuant to Virginia Code 801-184, declare that she is immune from civil liability for Depp's claims in this complaint and for the statements in her op-ed, because Miss Heard's op-ed is regarding matters of public concern that would be protected under the First Amendment of the United States Constitution by Miss Heard, blah, 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 fucking blah. Here's the thing. The First Amendment applies to the government. All right, you do have a right to free speech, but you don't have an unlimited. You can't yell fire in a crowded theater, for example. And you can't publish defamatory things against somebody and cause them harm that are false. So if the jury concludes that what she is saying is false, then it's just a matter of damages from there. So the first claim that Amber Heard is saying is she wants to make the court judge that she is immune and all of her statements were protected under the First Amendment, which they're not. So that claim will fail, 100%. Then defamation and defamation per se. She's claiming defamation against Johnny Depp. There was a GQ article. It contains the following false and defamatory statements, implications of Miss Heard. Depp falsely alleged that Miss Heard committed the crime of perjuring herself in connection with the 2016 DVRO, Domestic Violence Restraining Order, preceding statement with no truth, judicial statements whatsoever. Depp further falsely alleged that Miss Heard fabricated the bruising on her face and otherwise perjured herself in connection with the 2016 DVRO by stating that Depp was empathic about his version of the events. Miss Heard was at a party the next day. Her eye wasn't closed. She had hair over her eye, but you could see the eye wasn't shut. 25 feet away from her, however, how the fuck am I going to hit her? Which, by the way, is the last thing I would have done. So that's one of the statements. So you've got some defamatory statements that she claims that Johnny made about her. And the last one is this violation of the Virginia Computer Crimes Act. The Virginia Computer Crimes Act prescribes harassment by computer, which occurs when any person with the intent to coerce, intimidate, or harass uses a computer to communicate obscene, vulgar, profane, lewd, lascivious, or indecent language, or make any suggestion or proposal of an obscene nature or threats. So through the conduct described above, Mr. Depp, either directly or through his agents, including Waldman, acting on his behalf in Virginia, has launched a nationwide campaign, including from or through Virginia, using this Virginia litigation to harass, abuse, and discredit Ms. Heard and to cause harm to her economically. Mr. Depp, individually and through his agents, blah, blah, blah. Anyway, that claim, I don't see her claims going anywhere. But that's why the testimony has gone all over the place. Both sides are claiming that they've been defamed. Miss Heard, her claim is $100 million. Not on her. I mean, she's worth maybe 8, I think, is what the last estimate I read was. And how has she been damaged to the extent of $100 million? And they're using the litigation, like this litigation itself is a violation of the Virginia Crimes Act, which it's not. So I don't think any of her claims are going to be merited. Johnny Depp is suing for $50 million, and that's much more of a likely scenario. Johnny Depp lost for sure Pirates 6, and I think his fee in that was $22 million. So when you have Johnny Depp come forward and he has provable economic damages, it's really amazing to see, or it's not that far of a stretch to see that his damages are real. Amber Heard, on the other hand, she has Aquaman, and I don't know much else. But so look at Amber Heard. Now, she has to prove her damages. Let's just analyze where the trial's at right now. Right now, the plaintiff is rested, and they presented Johnny Depp. They presented psychologists who analyzed Amber Heard. They presented some fact witnesses that talk about whether they've seen abuse. They've also had economic damages. So that's what essentially the plaintiff's case. Now you're going to hear Amber Heard's side. Amber Heard testified on direct, and that's where the trial last left off. They were done with the direct examination. And remember what direct and cross is. Direct examination is, and then what happened? And then where did you come from? And, open-ended questions. And cross-examination is, isn't it true that you lied on this occasion? Isn't it true? And it's not? Well, here, look at your testimony here. Isn't it true that this happened? And basically you're testifying, but you're getting the witness to say yes or no, yes. And usually you have to know the answer to the questions that you're asking, because if you don't give a witness that's that hostile the opportunity to explain themselves. So the trial last left off after the plaintiff rested and that we just had the direct of Amber Heard. Why did Amber Heard go first? Well, she went first because she testified about a lot of things, right? And as they go forward, now they're going to be able to have other people repeat her testimony, repeat what they call prior consistent statements. Yes, she told me this. Yes, she told me that, And so you're going to hear a lot of repeat, but you're going to have an incredible cross-examination. And so we'll get into that on part 2 of this. But aside from that, so she has to prove that she was not only defamed by Johnny Depp, but that she has economic damages. And we're going to see, I would think we're going to see an expert on her side similar to what we saw on Mr. Depp's side. However, I think her economic damages might be a little more speculative, but we're still going to see somebody testify that she's got $100 million in economic damages. Now, there was something that happened during the trial that everybody probably saw. When she brings up this Kate Moss incident, she said, I was at the top of the stairs and I felt similar to Kate Moss. In other words, there was some allegation that he pushed her down a flight of stairs or something like that. Well, look at this. When she says that, Johnny Depp's lawyer, I don't think expected her to testify about that. And you could see the gears clicking in his head. And I basically fist bumped his partner. It was like, it was going like that. And he was excited because it opened the door to that event.
I don't hesitate. I don't wait. I just, in my head, instantly think of Kate Moss and the stairs. And I swung at him. And all of my relationship to date with Johnny.
Once her case is done, Johnny Depp and his lawyers will have the opportunity for rebuttal. So whether Kate Moss comes in and testifies, or whether there's somebody else, some other fact witness, and I guarantee it's going to be some other fact witness, is going to come in and testify in rebuttal. And what rebuttal is, you have to specifically only reference things that were referenced in the prior testimony or the prior case of the defense in this case. So you can't just bring up stuff you've never brought up before. It has to be specifically targeted to something that the defense brought up. You watch what happens. I bet you there's going to be a big moment in this trial when that issue of the Kate Moss story comes up. And it's going to be some great fact witness. And we'll see what happens there. So this is kind of just an overview of what the complaint was, and what they have to answer the complaint, and then they have counterclaims. And here's the other thing about what this judge has done. This judge has limited this trial to so many hours per side, and there isn't a whole lot left. I bet you there's maybe a week of this trial left, if that. And she said, once you're done, you're done. Once your hours are up, they're up. If it's in the middle of a witness, it's in the middle of a witness. And they're counting down. And I don't think that the defense has been too judicious with their time. They used almost the same amount of time in defending on cross-examination that the plaintiff has used. So we'll see how this plays out by the rest of the week. This is Bruce Rivers. Thanks for watching. Follow us on Instagram. Follow us on Twitter. Like, subscribe. We're also doing a little thing on Patreon. Subscribe to Patreon. We're helping some good people out with that dough. And we'll see you next time here on Criminal Lawyer Reacts.
Bruce Rivers, he's the criminal lawyer.
Who is he?
Bruce Rivers, he's the criminal lawyer.
And who is he?
Bruce Rivers, he's the criminal lawyer.
And what he do?
And it's gonna react to all the self-snitching.
Hi, this is Bruce Rivers. Welcome to another episode of Criminal Lawyer Reacts. I'm Bruce Rivers, board-certified criminal defense lawyer, where I actually try cases. Today we're talking about the Crumblies, and Ethan Crumbley has been taken into custody, and he was given a firearm by his parents.
So we were notified by Detroit. They had received a tip that the vehicle had been seen. We were notified at 23:05, which is 11:05 p.m. Our fugitive folks arrived on scene with Detroit at 23:25, which is 11:25, just 20 minutes after the call. They arrived downtown Detroit to be with Detroit. Detroit had seen the car, had secured the scene, had established a perimeter, done some great police work. Ultimately, at approximately 1:30, fugitive apprehension team took custody and possession of them, and they were formally lodged in our jail, where they remain at about 0300, about 3 o'clock in the morning. So they are in our jail. All three of them, the son and both parents, they are segregated, each individually in isolation.
And it's just so sad. And he went and shot up the school, and he killed 4 people and injured several others. No real reason why. I mean, he was brought into the school principal's office to talk, and the counselor's office to talk about some drawings that he had made and how disturbing they were. And the mother had been texting him and said, you shouldn't have gotten caught.
instead of admonishing him for not caught for the shooting, but caught for drawing bullets and whatever he's drawing. His kid's fascinated with whatever. But it was a real problem, and they brought him into class. Well, here's the thing. This is kind of groundbreaking in the sense that the parents bought him the gun, right? In other words, the parents pushed the ball down the fucking hill. And then all of a sudden, now are the parents liable for any of the damage that ball does in the village? Okay, I mean, I'm just using that as an analogy, and so it's a real legal question. I don't think anybody's ever been charged like this before. So let's take a look. Well, first of all, they went on the run, or at least they were in hiding. And maybe they were in hiding because of media or whatever, but they were supposed to turn themselves in, and they didn't. And they were found in a commercial building. And so let's take a look at the court appearance that the parents had.
Arraign you first, so if you'll please make sure you get close to that microphone so that we can hear you.
At an arraignment, there's two things that happen. One, in some jurisdictions you enter a plea, but there's generally speaking you get a copy of your complaint or indictment in this case, and that shows you what you're charged with, and you can have them read it in open court on the record, or you can waive reading. Generally people read and write English, so they generally waive it, and then they determine conditions of release. And in this case, it'd be some kind of bail. That would be.
If you cannot hear or see me, please put your hand up, and we'll stop the proceedings and then try to figure out what's going on. Do you understand that you are charged with the following counts? Count 1, involuntary manslaughter, which is punishable by up to 15 years in prison and or to a $7,500 fine, and mandatory DNA for the death of Madison Baldwin. Do you understand that that is a charge for count 1? Mr. Crumbley, you need to.
So involuntary manslaughter, and that it doesn't mean that you intended to cause the death. That's hence involuntary, and it's caused by culpable negligence. In other words, that you were aware of the danger that something could happen and you disregarded it.
I understand. Do you understand that you are charged in count 2 for the death of Tate Meyer? Involuntary manslaughter, which is punishable by up to 15 years in prison and or up to a $7,500 fine, and mandatory DNA.
Here's the other thing. When you have multiple victims like this, the court can stack those and sentence them consecutively. So if we're looking at 15 years maximum for each death, they'd be looking at a maximum of 60 years.
I understand. Do you understand that you are charged in count 3 for the death of Hannah St. Juliana with involuntary manslaughter, which is punishable by up to 15 years in prison and or up to a $7,500 fine, along with mandatory DNA testing?
I understand.
Do you understand that you're charged in count 4 for the death of Justin Schilling with involuntary manslaughter, which is punishable by up to 15 years in prison and or up to $7,500 fine, along with mandatory DNA testing?
I understand.
Do you understand that you do have the right to plead guilty or not guilty to all those counts?
I understand.
And do you understand that you do have a right to a trial, either by jury?
So now the judge is reading the charges, but she's not reading the probable cause section of the complaint. In other words, she's not reading all the details that give rise to how and why she was charged.
Or by judge. And at that trial, you would have the opportunity to call witnesses on your behalf, confront witnesses that have been called against you, and or to remain silent, and that you'd be presumed innocent until proven guilty beyond a reasonable doubt. Do you understand all those trial rights?
Yes, Your Honor.
Are you on probation or parole for any other offense? Ma'am, I'll ask the question again. Are you on probation or parole for any offense?
No.
And how are you pleading to count 1?
Not guilty.
How are you pleading to count 2?
Not guilty.
How are you pleading to count 3?
Not guilty.
How are you pleading to count 4?
Not guilty.
And do you understand, sir, that you are charged in count 1 for the death of Madison Baldwin of involuntary manslaughter, which is punishable by up to 15.
So then they go through the same rights with the husband, the father. And so this is going to be a real interesting case because it'll be, how many of these shootings have we seen? How many school shootings have we seen over the years? It only happens in America. It only happens in America. It's ridiculous that we see these school shootings. And you have a young kid, you buy him a fucking handgun, a 9mm Sig Sauer. Where's your brain? Especially if you got a kid that's a troubled kid. Where's your brain? And that's why, if you give a kid a match and you have any kind of inkling that he's going to light a fucking fire, you don't give him a match. So apparently the guns, the parents have said that the guns were locked up. And whether they were or not, that would be a good defense. Because if you bought your son a gun and he went out and used it later, if you did everything you possibly could to keep it safe, but he did something, to thwart that, that would be a defense. So the other part of what they do at that hearing is they set bail. And in this case, the bail was set in the amount of $500,000 for both parents. So now all three of them are in jail. Now, we're going to have a lot more things that come out. You're going to have search warrants executed. You're going to have hard drives searched. You're going to find out a lot more information about the liability of these parents. But in looking at this, I can't even begin to tell you how devastating this has got to be for those four families to lose somebody to senseless gun violence. It is my understanding that Ethan has lawyered up and is not talking to the police, which, in a way, they don't need him to talk to the police because they got him pretty much cold. But that's what I would have advised. I would advise him not to say anything to the police. He doesn't really have much of a defense, I don't think. And it's just awful. These school shootings are just terrible. So we'll follow this as well. And we'll see you next time here on Criminal Lawyer Reacts. If you're watching this, subscribe. If you have a gun, use it responsibly. If you're a parent with a gun, lock it up. Make sure that that your child doesn't have any access to it. And here's the other thing. If you're a student or if you're a parent or if you know somebody that has kind of a sketchy psychological makeup and may pose a threat to somebody, don't be afraid to say something. I think they were looking into this kid prior to this, and look what happened. We don't need to lose any more children. For what? For what? For nothing. So, again, this is Bruce Rivers. If you are watching this, you should follow us on Instagram, follow us on Twitter, subscribe, and we'll see you next time here on Criminal Lawyer Reacts.